Welcome to Open Minds, a Freedom of Thought podcast series, interviewing the people who bring courage and independent thought to the challenges of today.
All right, welcome to the Freedom of Thought podcast. My name is James Burnham, and I'm here to interview Jay Edelson from Edelson PC, the founder of the firm and one of the nation's leading plaintiffs attorneys. Thanks for being here.
This is a great studio. This
Yeah,
is
it's pretty
probably
cool, right?
the most well thought of studio I've been in, most professional. So
Well,
I'm excited.
After this, maybe you'll be invited on the Rogan podcast, and you can compare them.
That's the dream.
That is the dream. It's certainly my dream, and I would go to Austin for it. I wouldn't make him come to me.
Oh no, he would be a fun conversation because people have different views about him, but my view is he's curious. Like he's really actually trying to explore ideas. So
Absolutely, as are we.
Good.
But first, let's just talk a little about your life and your background and kind of build into something a little more substantive. So where are you from? Where'd you grow up?
like first, I find my life and background fairly boring. So hopefully we can do this.
Well, we can go quickly.
We can. I'm from the East Coast. I was born in New York, and then moved to Boston
In
when
the
I
city,
was
or?
5. Yeah, but I mean, I was an infant then, and then we moved to a suburb of Boston when we were 5.
What
when I
did
was
your
5.
folks do, and what all that?
So my dad, who's not been in my life since I was 8, is a doctor. So we moved because I think he was doing residency or something in Boston. And my mom runs she just actually retired, runs a art and crafts program for developmentally disabled adults.
Oh wow!
So interesting stuff. Not huge, a huge money maker. So we grew up. It was kind of an interesting setup because my dad had plopped us in a pretty cushy suburb where a lot of people had money, but we didn't have money because when he left, he took his money with him.
Yeah.
So it was an interesting kind of lens into the world.
That is interesting. So, I mean, do you think that had an impact on your kind of worldview and all of that? I'm sure it did.
Yeah, of course. Yeah. So I'm not like a total Nietzschean, but the idea of that you kind of look at people in power. Nietzsche's view is that people in power get their morality based on their own characteristics, and then people not in power get their values by having the opposite views of the people in power. I wouldn't go that far, but I definitely viewed my classmates and people around me, although I liked them, we were friends and everything, I didn't think the fact that they had money made them special. I didn't think that it meant anything. My view was like, you've got to kind of prove yourself individually. And that was my view really from being a kid on.
And is sort of the implicit point there that they had the contra view that they were special because they were rich and fancy?
So that was how I read it then.
Yeah, sure.
But
Interesting.
I think as I've grown up and gotten older and spoken to them as adults, that wasn't necessarily their view. But
some rich people are very self-satisfied, though.
They were, and we had kids who they were smashing $300 tennis rackets where like I had like $5 to get through the week, and so I would see that and just be like, oh my goodness, that is the worst thing ever.
Wow.
Or they would have a brand new sports car and they'd smash it and get a new one. And that was not my life at all.
That's interesting. So, I mean, at what age did you then become interested in sort of the justice system? I mean, did you always want to be a lawyer? And do you think this sort of played a role in that?
So my decision to go to law school had absolutely nothing to do with the law or anything that someone could think of. So I don't know how deep you want to go.
We got all day.
Okay. So I was like a preternaturally shy kid, like so shy that I couldn't raise my hand in class. And when I was in college, when I was like 21, I kind of had this awakening moment where I said, okay, do I want to go through life like this? And my view was the track I was on, I was going to do something in computers and be in a basement somewhere working, and I wouldn't ever speak to anybody. And I thought that's not really the best use of kind of my talents or who I want to be. So I said to myself, I was always very competitive and I always kind of believed in myself at a deep level. So I said, what I'm going to do is I'm going to force future Jay to go into law school. And I know it's going to be tough for him because he's probably going to think he's
So
going to
what
fail.
age are you having this internal dialogue?
21.
Okay, so like in
20,
college, basically.
like junior year of college.
Yeah.
Right around then. And so I was like, we're going to do it. And good luck to you. And, you're going to have to get over this or you're going to fail out. And I kind of was betting on myself that I wouldn't fail out.
Okay. And so did it work? I mean, like, did
Did
it
it
break?
work? I don't
Yeah, well, I don't know.
I'm
I mean,
speaking now.
you are speaking now. I mean, do you still feel, I mean, obviously, I'm sure you're sort of an introverted person generally because
Correct.
that's a, innate thing.
Yes.
But I mean, do you still feel that whatever sort of apprehension about speaking, or is it just you've conquered it?
That's gone. But I want to be clear. That wasn't like I made the decision and then in law school I was raising my hand and
No, it's like a decade of work, probably more.
yeah. I mean, when I was going to court at the beginning, my daughter still makes fun of me for this. Like it was flop sweat. And I'm a plaintiff's attorney, so I'd be going and asking for fees. And the last thing you want is a plaintiff's attorney to start sweating when the judge says why you're entitled to fees. So I was told when my first big law job, I was told I didn't have the personality to be a litigator. And I said, that's why I want to become a litigator, which
so
makes just no sense at all in big law. They don't, that's not a response they get.
So I want to talk about that, but I want to take one step back first. Where did you go to law school?
Michigan.
And what drew you to Michigan? You're from the East Coast. How'd you end up at Michigan? I think you went to Swarthmore for college, right?
Brandeis.
I don't know why I have Swarthmore. Sorry about that. So how did you end up at Michigan?
So, I didn't have like a huge pipeline into understanding different schools. So the way I ended up in Michigan, kind of all my answers are going to be odd. So I apologize for that.
Odd is more interesting.
Okay. So when I applied to college, I got into all the colleges that I applied to. And Brandeis is not the most competitive school, and it was great for me. When I applied to law school, I looked at it and I said, I think there's a chance I'm going to get into all the law schools I apply to. So I'm going to apply to Michigan. So I'll get rejected. So I'll realize that I didn't make a mistake. So in my math, I was going to end up at like NYU. And Michigan was just a little bit more competitive. And I was like, I've got no shot at that.
Okay.
And so I got in and...
So it was the best one you got into, basically. Or most competitive.
It was, I mean, who knows what the best is
or
most competitive
or
anything. No, but then I really liked the idea. I wasn't going to go just because it was, ranked at whatever it was at the time.
Yeah.
But I needed to get out of the East Coast. I hadn't like traveled, like we didn't go on vacations or anything. So the idea of leaving and going to Michigan, it was like a huge, like someone else who's going to like Europe or something.
You didn't think about Pepperdine or UCLA? I mean, Michigan is a funny.
This shows kind of how local I was. Like California would have been like the moon. Like I never even thought about a California school. Michigan seemed very, very far away.
Oh, that's interesting.
Yeah.
Were there any professors that were particularly influential or?
In college?
Yeah, no, in law school, like any law professors or any courses that kind of you really enjoyed?
Yeah. I mean, it's always the ones that you don't expect.
Sure.
So our property professor, Professor Creer, was, I hate characterizing people's political views, but I viewed him as someone who was a conservative thinker. And he had a very clear view of the judiciary, of that in order to understand decisions, you have to also kind of appreciate that these are individuals who are making real life decisions and are thinking about the impact of their decisions. So, when you go to kind of a more theoretical school, sometimes, you think, I was a philosophy major, and you think you're back in philosophy class and you're just trying to figure out, what is kind of the ideal.
Mm-hmm.
And that's how you write your decisions. And his view was there's truth to that, but also grow up a little bit. And then, he taught us all these crazy things like about transaction costs, which as a liberal, I didn't know about. And, the part where he really started shifting my mindset was when he was talking about, and this for you, this is all, like ABCs and stuff.
Yeah, they read this to us in our beds.
I'm sure
here at
when
the
you're
Federalist
five.
Society. Yeah.
But he talked about, apartments that were uninhabitable. And so they were closing them down. And I was like, of course, that's the good thing. And he goes, okay, what's the alternative though? Where are those people going? If they're ending up on the street, that's worse for them. And his view wasn't, of course, we need to have uninhabitable apartments, but it did make me realize that you got to think practically as well. It's not all about just ideals. You have to look at what is the next best
option. Does the regulation
option.
mean better apartments or fewer apartments? And how do you kind of do a comprehensive cost benefit analysis of that?
Right. And that is not how I was trained to think before.
Well, I'm glad at least you think that way now.
Yeah, I mean, I'm an adult, so that made sense. And that was, that was the most fun class I had. And I didn't think I'd be interested in property at all. Fee simples and all of that. I'm not interested in.
Property is a fun class. Do you still use any of that, you think?
I use the intellectual framework all the time, but no.
It's more just like a relic of.
Yeah. No,
that thing with the fox on the beach. What is it? Pearson versus Post. Anyway,
that was a long time ago.
So, okay. So after law school, what did you do next?
I went to Michigan, so I was required to go to a big firm.
Right.
And so I went to, a defense firm, which is now a relic. It doesn't exist anymore. And that was in Chicago.
Which one was it?
It was called Hullab and Koff.
Okay.
So it was more of like
did it get eaten or just kind of fracture?
Yeah, it like blew up. It's blew up the word. Blow up seems like it's
it collapsed, perhaps. I don't know.
Blow up could also mean like it did really
well.
No,
I think we all knew what you meant.
Okay, yeah. It was like one of the first firms to just totally collapse,
like a Howry kind of thing.
Yeah. It was basically they made. It was more of a lifestyle firm, and then they were like, oh, other firms were making more money, so they brought in partners who had a lot of clients, and the partners looked around and said, no one's working, so they left and took all the good people, not the good people, but the people with business with them, and then it just disintegrated.
Wow. Were you there when it fell apart?
No.
You'd already left?
I'd left, yeah.
And then what did you do after that? Is that when you flipped to the plaintiff side?
No, I went to one other, it was a boutique firm, and called Grip on Eldon.
Okay. And then what led you to want to sort of switch sides of the V and go to the plaintiff side?
So I really liked practicing law, and I was happy to do it on the defense side. I had a lot of confidence in my views, and was willing to. Although I was very introverted publicly, I wasn't in terms of one-on-one conversations, and so I was very willing to express my views in strong terms, which, as you know, big law loves.
Yeah, of course.
So, I was the guy saying, this is just, we're doing it wrong. Like, we're literally responding to arguments the other side isn't making. And at my first firm, they kind of didn't like that I was noisy, but also were like, he's winning. And so there were enough partners that liked me, and I had a good.
Can we go back to that?
Yeah.
When you say you were winning, so what kind of stuff were you doing at the firm?
I was defending class actions.
And when you were winning, like on the motions, or were you going to trial, or like what was your sort of practice like?
Oh, it was. I should
have asked about that before, but I'll do it now.
Yeah. No, it was consumer class actions, and most of it was driven by one firm in Chicago, and what they would try to do is find very technical violations of the law and come up with creative theories, which they would then hide to make it really hard to figure out what they were trying to do. I loved that. It was all just pure strategy. So one of the kind of first big wins I had, I don't know if this is getting too into the weeds.
No, I'm actually really interested. Please.
So we had a case. I looked at the complaint. I then grabbed all the other similar complaints this firm had filed, and you could see how the complaints evolved over the last 12 months and what they were taking out and what they were putting in. So I figured out what their theory was going to eventually be. And then I figured out that their theory was wrong. So we actually went to them and said, your theory's wrong. Why don't you dismiss us? Go after all our competitors. They're not going to understand this. Keep them busy, and you'll probably get settlements, which they did. They made a lot of money on those suits, but they let us go. And we paid nothing.
So you did this so you didn't file a motion to dismiss
No.
or what have you. That's really interesting. So you went to them offline and said, I can blow up your machine or you can let my client go. And they said, we'll take option 2.
Yes. Although, I mean, they didn't understand that they were wrong. So, it wasn't like.
They weren't like, oh, you got me.
No, they looked into it. They were like, this is insane.
Oh, once they reviewed it, then
they reviewed it and were like, yeah, this isn't worth it. And then since I was a little bit too cocky, the one thing that we argued out was if you looked at Illinois law, they were required to pay our costs when they dismissed. So they owed us like $200. And that was my first argument in court.
Who won?
I said to the
Did you get the money?
We did. I said to the court's like, I'm not going to give you $200. And I said, Judge, it's mandatory. And he did not like a first year saying mandatory. Uh-huh. And he said, you guys figure it out. If it's mandatory, you get the $200. If not, you don't.
Was it your idea to sort of go to them offline?
Yeah.
That's really interesting. I mean, I've never heard of a defense lawyer doing that. It's a good idea. Does that happen with you now sometimes?
So, yeah, except I don't think they do it in an artful way. We got a lot, not anymore. At the beginning, it was a lot of, we are Kirkland, and just based on our reputation, you don't want us on the case.
Yeah, you should just give up because we'll kill you.
And my view was, to me, that was back to, me growing up and, the rich kids being like, because we're rich, we win. So that was kind of more motivating to me.
That seems very unpersuasive. But I mean, it's a really interesting idea to send basically like a draft motion to dismiss or some.
We didn't even do that.
What did you do? Just like go talk to them?
Yeah, literally it was, I don't believe in kind of an arrogant approach. Like I believe in more kind of a curious approach, even when you're talking to the other side, or especially when you are. So the approach was, look, we've looked at the complaint. We think that we understand where you're going with it. We think what you're going to argue is this. You don't have to say if that's true or not. If that's true, here's what you're missing. And then they came back and said, that's interesting. What next? And
it's such a good idea too, because at that point, I mean, as you know now, they've invested so little time and money into the case. It's smart to tee up the most dispositive issues at the beginning because it's easy for them to walk away.
Well, we weren't even telling them to walk away.
Yeah.
We said you've got 20 other suits against other companies and law firms that aren't thinking this hard about it. Go get them. Yeah. So it didn't cost them. They made a lot of money, and our duty was to our client, not kind of to the public in general. And the fact that our client's competitors got dinged was fine with me.
Yeah, of course.
And
I like it. So then what? So now back to where we were a second ago. What caused you to want to flip to the plaintiff side? And was there anyone you really admired doing that kind of work, or how did that come about?
So at the second firm, I had the same attitude and got promptly fired because it was not a firm that was interested in
your opinions,
in my opinions at all. So this shows how naive I was, but I was really like isolated as a kid. I had not like seen the world. I didn't understand the world. So I was given an assignment of looking through millions of documents and doing a timeline based on it for an argument they were never going to use. So since I'm super smart politically, I went to the partner and I said, it feels like my job is to hand you a timeline every month and then you throw it in the trash. Can I suggest for efficiency, I just throw it in the trash myself? That did not go over well. I thought it was funny.
Was he really just throwing them away?
Yes, 100%.
Why do you want him? Just to turn the bill? I mean, what's going on here?
Yes, we're just billing. And they were also wrong about their whole theory was wrong. We actually could have used this stuff, and they just totally misunderstood,
the senior lawyers.
Yes, they totally misunderstood the law.
And they weren't even interested in hearing from you about how they were wrong?
They let me write a memo, and then they agreed the memo was right. And it was really, I mean, this is really in the weeds, but they they had already made the opposite argument in a similar case, and in their briefs had just gotten the law totally wrong. So it was very hard for them to say, oh, shoot, they literally just misread a Michigan Supreme Court case and we're under Michigan law. So they just said, Jay, can you just bill? And my view was absolutely not.
Wow. Okay, so you got fired.
I did.
And so then you were like, well, it's easier to be a plaintiff's lawyer. I mean, like, what happened next?
No, my view was I don't want to live in this system where I have to like beg people to be able to make arguments, which I think are going to help win. So I looked at the defense side, and to be clear, I worked with a lot of really, really smart, good lawyers, and I learned a lot from them. But I didn't look at anyone where I was like, I want to be you in 5, 10, 15, 20 years. On the plaintiff side, they were having fun. They were bringing cases that were exciting to them. When we won that big case, the class action defense case, the partner, like I got some firm award for it, and the partner said, you should realize we just lost $3 million in billables, but good job. On the plaintiff side, they were buying houses when they won. No, I mean he's right practically, but
the billable hour it's
insane.
Completely idiotic. I mean, I couldn't agree more. Not to digress, but go ahead.
No, but on the plaintiff side, they were buying houses when they won, and it wasn't about how do I maximize my wealth. It was about like I want interests aligned. So when we win, I want to be super happy about it instead of saying, oh, now it's going to be a worse year for me financially.
That is a very stark way of looking at the world. So did you start your own firm right away, or how did you launch?
So I went to a plaintiff's firm for a very short period of time. And then, when I was maybe 3 to 4 years out, I started my own firm.
So at this point, you're how many years out of law school? Like 8 or 9?
No, like 3 or 4.
Oh, this all happens over 3 or 4 years.
Yes,
Okay,
and since I was well trained at the defense firms, I'd been to court like twice. I'd taken I won deposition, defended 2. So
how did you start out? I mean, how does that work? Was it just you?
Me and a partner of mine who was.
Where did you find that guy?
He was at the first firm I was at. He was 2 years more senior than me.
Was he already a plaintiff's lawyer, or did you guys launch together?
I would say we launched together. He kind of had his own practice. Our idea was we were going to start a firm, and so he went and started like his own solo practice, not doing plaintiff's law. He had a different business model, and then I tried to learn how to do plaintiff's law at this other firm with the idea we would then hook up, which is what we did.
And when you launched, was it all plaintiff, or was it like a mix?
No, it takes time for plaintiff's
Well, that's what I was
going to
ask is, I mean, was he doing, like, how did you guys eat in the first few years? Did you have sort of some defense side stuff to pay the bills and then some moonshot plaintiff stuff, or how did it work?
Well, it wasn't moonshot.
Well, you know what I mean, but like some deferred comp plaintiff's
Yes.
work. How did it all fit together?
Yeah, no, I was the guy, if you had a $10,000 case, I was the guy.
I see. So you started with low risk, low.
No, those were paying cases.
Oh, I see.
Yes, and as you know, it is hard to bill on a $10,000 case.
No, of course.
So, and I always want to win first. So
yeah,
I would work really hard. I'd get paid, whatever, $1,500, but it was costing us $600 a month to run the firm. So it wasn't that difficult financially, and I actually learned a ton on those cases because the cases tended to be more emotional than anything else, right? Who's going to sue over $10,000 unless like people are really pissed off,
right?
And then also settling the cases are interesting because people are moving up or down in increments of $50,
right?
So they're a lot harder to settle than a $200 million case. Kind of ironically, a $200 million case. Once everyone agrees to settle, you start moving by 20 million, you realize there's so much momentum you're going to get there.
So like, I mean, there's probably some people on the that are going to watch this that work at big law firms and stuff. So I'm going to ask you more questions about kind of the economics of starting out. So like, did you just not, I mean, when you say $600 a month to run the firm, I assume that's costs, rent and malpractice insurance, not your salary and your partner's salary, right?
No.
So how did you guys make it work? Did you have a family at this point, or did you get, have kids later, or
I was married. My wife was in residency, so she was making not a lot of money. I think we lost money on her because we had to have, I shouldn't say we had to, we had a nanny.
Yeah.
So she
had a baby at this point.
We did.
Yeah. Okay.
Yes.
So how did you make it all hang together? I mean, that seems like a very risky, and I think a lot of young lawyers, that's part of why people stay in these big law firms, is the prospect of doing that is very intimidating. And they don't even, I think it's hard for people to even think through, how do you make it through the first year? So I'd love to just know more about.
So I think that one of the best gifts I ever got was the gift of very low expectations. No, I'm serious.
Yeah.
My brother was, an academic star, and a lot of attention was kind of put on him. And for whatever reason, I was considered the kid who was not going to succeed.
Was he shy like you, or was he more extroverted?
He more extroverted.
I mean, that probably had something to do with it, right?
No, our minds work differently. So he just dominated in school. He's just someone who, if he reads stuff, he remembers every detail about it. Just a really, really smart, like academically very, very smart. So, he was always the favorite student of teachers. Then I would go afterwards and they'd be like, you're failing this class. And I was like, I'm getting a B+. And they're like, right, but your brother, was one of the best students we've ever had. So anyway, because like when I went to law school, my mom and stepfather said, you're going to fail out. That was their absolute view, which was motivating to me. It also kind of takes pressure off of you.
Mm-hmm.
So when I started my own firm, I wasn't worried about not succeeding, because that was always kind of what I was told. I wasn't going to succeed.
Right.
So whatever, if I didn't succeed, it wasn't going to be like a reputational hit to me. So for me, it was just a lot more fun. Like I like sports. I like being competitive. And the idea that like your house is literally on the line is really fun. I mean, that's messed up to say.
No, totally. And so in the initial day or years or whatever, it sounds like you guys stayed afloat through these small defense side cases or fixed fee cases, I guess, right? The $10,000 cases.
I'm letting you finish.
Yeah.
I'm going to disagree with you. But
why don't I ask it in a more open-ended way? What was the revenue stream in the early years to sort of pay the mortgage and all that? And then how did the plaintiff stuff fit into that?
So basically, so I had a couple of cases that I brought with me from the previous firm. We worked together.
Yeah.
And so that meant they were already in the pipeline. But then what I tried to do, my business model was, I'm a weird guy. I wrote 2 memos of, this is the first 5 years of the firm. This is how we're going to do it. This is how we'll succeed. And then after we do that, here's how we're going to pivot and take over the world. The first 5 years, I tried to focus on cases that were really issues of law instead of issues of fact. The idea of having a case where it could go on for 8 years and I don't know if I'm going to get the document or not meant that our firm wouldn't succeed.
That's smart.
So it was right when the internet was taking off. So people in the plaintiff's bar, they're really slow. They're really behind the times.
Then or in general?
Always.
Okay.
But, and even on defense side too,
lawyers are not cutting edge people, generally speaking.
So I was looking at all these companies and my view is they're not going to get good advice. And I would look at different state statutes and I'd be like, there's no way anyone is going to be following these statutes. And so those ended up being kind of interesting issues of law, and we would litigate them. Or I kind of had the same approach where I would go to the defense counsel and I would say, look, I don't need anything from you. I just want to lay out why we think we're going to win. You don't have to say anything.
Right.
And then I'll explain kind of what the exit plan is, what a settlement would look like. and that worked. So I was making,
even in the very beginning.
Yeah. Oh, that was like one of the first things. I was actually a defense attorney who said to me, "Can you come over and I can explain to you why you're wrong?" And I was like, "Great."
Yeah.
And then we ended up settling like 2 days later. So my salary never went down. I made more money in my first year.
That's awesome.
But I had to grind it out.
Mm-hmm.
But it was fun.
And how do you find, I mean, where did the plaintiffs come from? Like, how do you get them?
So it's easier
then.
now. Yeah.
Yeah.
Back then.
I mean, now you're well known and it's probably a different model, but at the time.
Well, now, a lot of it's advertising.
Right.
But there wasn't that type of advertising back then. Now you do, Facebook ads, or I don't know, we have a whole
Twitter
marketing
and all
team.
that. Yeah.
Whatever it is, that's beyond me. But at the time you couldn't do that. I never was terribly interested in being on a billboard, nor could I have afforded it, I assume. I don't know what they cost. So it was more, a lot of times it was referrals. Like we would know these are the type of cases we would want to bring. And then we'd speak to other lawyers and say, hey, do you have any clients that fit this bucket?
And in the early days, you said questions of law. So was it like data privacy, kind of the stuff that you've made a big practice of in the years since?
A lot of it was, I mean, data privacy did not exist. So we did have privacy cases, but we had to dress them up as something different. Because if you said privacy, judges would look at you like, what are you talking? This was the era when, all the tech titans were saying privacy is dead.
Right.
So we thought, or I shouldn't speak for my partner.
Well, whatever.
But he didn't think this.
Okay.
He didn't. No, I thought that privacy was going to become a big thing. But I realized that I had to kind of dress it up a little bit differently.
So we're using like state common law theories to basically bring what today would be a data privacy statutory claim?
Yeah.
Yeah.
Yes. And breach of contract is always the most direct thing.
Right.
They promised this and they didn't deliver. But we brought other types of kind of interesting consumer fraud cases.
And in that era, was it like the person shows up and then you develop the case? Or was it, you'd come up with a theory, whatever, Facebook didn't exist then, I don't think, but like whatever, their equivalent at the time. I'm reading the terms of service. There's no way they're following all of this. I'm now going to go, find plaintiffs and go after them. Like, how did it originate back then?
Yeah, it was, lawyer first. So one example is
theory, then plaintiff.
Correct.
Yeah.
So one example is we sued a company called register.com.
Okay.
So, at the time, if you wanted to register a domain name, you really had to go through register.com. You'd pay $35. And then what they would do is they would put up a landing page where they sold advertisements. And my argument was how can they do that? They don't own the domain. They're just kind of squatting on it until you put up your own website, which would take a few days. So that to me was a really interesting case. From your look, it doesn't seem as interesting.
No, it sounds interesting. But
no, that's okay. I don't mind. But just to give you a sense of the world we were living there, when we argued the case, courts didn't understand what it meant to register a domain name. So we lost at the trial court because they said nobody has any right to a domain name. And then when we got to the appellate court, we said, okay, so that means your domain name for your appellate court, we could just take it over. And they said, okay, yeah, that's bad law. And so we won that.
That's awesome.
Yeah.
Okay, so then what was your first, I have a list of some of the cases from your bio, but maybe a more organic way to do this. What was the first like big win? Like what was kind of the breakout moment for you guys? If there was one.
It depends how you're defining a win.
Settlement, the first big, I assume you had at some point a large monetization event that enables you to scale. in a meaningful way.
I love talking to conservatives because in my crowd, nobody would say monetization event.
A liquidity event?
Yeah, none of that. That's great.
When did you make a lot of money for the first time? How about that?
So,
and what was the case or cases?
Yeah, so it was actually a case against Bally Fitness,
Okay.
health club, where they're in our minds they were violating a statute where they were overcharging people. And we fought that out and we settled the case and got $2 million in fees. And there were two of us.
That's a lot of money.
That's
real money.
It was real money. My partner, and we'd done well in other cases too.
Right.
So it was like an extra $1 million each. And my partner retired and was like, I'm done. And,
oh, wow. Really?
Yeah.
Is he still retired?
Yes.
Wow.
Yeah. That was it for him. He was significantly more risk averse than me, which made it interesting. You know, being a plaintiff's attorney, you can't be risk averse.
Yeah, right.
Like our whole dynamic was me saying, "Let's conquer the world," and him saying, "Let's do nothing.
Let's keep this 40 acres and be cool."
Correct.
Yeah,
which is fine. You know, and I didn't when I kind of took that money and said, "Now I want to do stage 2 of the firm and grow it." I didn't understand I was taking a huge risk. Because I put all the money into the firm and I was just like, okay, it's going to obviously work out. And I mean, it did, but like there were like 6 different moments when it could have not worked out.
Interesting. So then he retires, and then what did you do?
I kind of joined forces with another attorney, a plaintiff's attorney, named Scott Camber, and we kind of melded our two firms. Now, my firm was me and one associate. We had gotten fancy by then, so we had gotten an associate, and then it was him, and maybe he had like 2 associates or something. So we thought we were kind of a pretty big deal.
That's awesome.
Yeah, and he was in New York, so we had 2 offices. It was crazy.
That's awesome.
Yeah.
And so then maybe you could just kind of. So how long ago was that you guys merged into that firm, give or take?
I don't know.
20 years ago?
Yeah, 20 years, something like that.
And so what happened next?
So at the time, this was right after the Class Action Fairness Act was passed. And so the Class Action Fairness Act had really made it so most class actions were going to be fought in federal court rather than state court. And I realized that meant that the whole game was going to change. Right. So once you have cases in federal court, it's easier to track everything. You're going to end up with more MDLs. There aren't really state court MDLs. Right. Certainly at the time there weren't. Now there's a little bit in like California, et cetera. Mm-hmm. So I realized like we needed to have a bigger footprint so we could win lead. My partner Scott and I kind of were learning how to do that. He was more advanced than I was in terms of understanding that. But it ended up not being a great fit because, what I learned about myself was I really have confidence in my ideas. And if I'm confident in them, I'm not terribly excited for other people to say, no, we want to do something else. My view is that's fine, but like you got to do it on your own. And he and I are friends still. It wasn't bad blood, but he wanted a very different type of practice.
So how long? So is this when you formed what is now Edelson PC?
Essentially, yeah.
And how long ago was that, give or take? Like a couple of years after you guys launched the joint venture?
Yeah. It was like we lasted like 2 years.
Okay. Great. So then, what are your favorite cases you've handled, or sort of most notable? I have a few from your bio, but I'd probably easier just to ask you in an open-ended way.
I'm sorry, I don't mean to be difficult. I don't know what you mean by favorite. Favorite in what sense?
Proudest of the outcome, most interesting. I mean, however you want it. I mean, things that, if I said, what have you been working on that you thought was really cool and interesting, what would you say?
Right now you're saying?
No, or at any point, then? Whenever. I mean,
So I don't know if I'd think about a specific case. What was really interesting and fun was that almost all our cases were cases of first impression.
Uh-huh.
So when we were going in front of judges, you had their attention. You could tell the defense attorneys really cared about what was going to. Here's an example to make it more concrete. We had the first class action filed against Facebook, and they asked me to come to meet with them, and I went out there, and the defense attorney, someone who I love, I think he's one of the best. Well, he just retired, but Mike Rhodes, just a phenomenal
Which
attorney,
firm?
Cooley. And it was him, and then I think like the general counsel for Facebook at the time.
Was that Ted Oliot?
I don't remember.
I bet it was. He's a Federalist Society guy. Anyway, I think I know him, but anyway,
Yeah,
nice guy.
This was a long
Yeah,
time
of
ago,
course. Go
and
ahead.
so if you
Yeah.
told me it wasn't actually the general counsel, it was assistant general counsel,
Yeah,
I would believe you.
no problem.
I know Mike Rhodes was in the room.
Yeah.
And their first question to me was, this is our first lawsuit, first class action brought. If you were us, how would you handle class actions? Would you fight them or would you settle? How do you make that decision? That type of thing, it was so fun for
Mhm.
me. I've always been someone who I was a philosophy major in college. I care about ideas. Having those types of conversations, I just didn't think I'd be in that position. So when I think about favorite cases, I kind of more think about favorite moments like that, where everything we were doing was new. And whether it was, pushing new cases and you talk to the defense attorneys, who would say
Mhm.
things like, they're off the record conversations
course,
where people who I respected would say, your business model's crazy. Like, you're betting on privacy. Like, don't do this.
Right.
Those were kind of the moments that were really interesting to me. And then we would talk about, what do we think is going to happen in the law in the next 5 years? So it's more kind of like those moments rather than necessarily specific cases. I have cases, of course. We had Spokio, which went to the Supreme Court.
I'm definitely going to ask you about Spokio.
Yeah.
I want to ask you one before that, though, which is, I don't know how to pronounce it, but Visalis. It's a robocall case.
Mm-hmm.
Or if I read your bio right, it went to verdict. You had to try the case.
Yeah.
Why is a robocall? I mean, that seems pretty odd to me. Isn't it like the facts are known, the law is the law? Why isn't this getting resolved on summary judgment or something like that?
Well, I They don't. I mean,
Yeah.
they generally settle for especially at the time, for nothing.
And to the audience, this thing resolved for $925 million. So this is a significant case.
It's not resolved. That
Oh, it's
was
still
the
going.
verdict.
That was
It
the
is.
verdict.
Yes. No, it's.
So what the heck happened and what's going on?
So yeah, their trial defense was not to have any defense. It was very bizarre. It was a 3-day trial.
What?
Yes.
So what's the what was the strategy?
Their strategy?
Yeah.
I don't know.
Drag it out and not pay?
So what we just found out was that after they lost, they were just trying to delay things and then ended up selling their assets to another company.
Yeah, so delay and not pay. That's the strategy.
Yes. And for some reason, they think they're going to get away with that. And we're very excited for the next step.
How often do your cases become like an asset hunt adventure as opposed to just winning on the merits?
Very fewer asset hunts because we're generally bringing suit against
big companies like
Yes.
Facebook or whatever.
Yes.
That pay.
Yes.
Yeah. And with those kinds of companies, I assume the judgment is finalized, the money's there, next day or whatever, but in some timely fashion.
Yeah.
It's a funny issue though for most lawyers listening because they're at law firms where the client pays a bill. I don't think a lot of people listening to this right now know what you do after you get the judgment. Like, do you give them your wiring information? But I assume most big companies, they just send the money and it's easy.
Yeah. I mean, even after, a verdict, as you know.
After it's final on appeal and all of that.
Yeah. But it usually, even after a verdict, you're going to end up settling the case.
Right.
So, and then when there's a settlement, like Facebook, we got a really good settlement on biometric privacy. It was $650 million. And I think for Zuckerberg, it was kind of the tip that he had given the waiters the night before.
Yeah, I don't think it probably affected his life too much.
No, I don't think so.
Yeah.
But it was a lot for us.
That's awesome.
Yeah.
So let's talk about Spokio. Could you
Yep.
just explain, most people will at least be familiar with the Supreme Court case. But could you just explain what the case was about, and then we'll get to the part where it goes to the Supreme Court?
Sure. Pretty kind of not the most interesting case on the facts. Legally, it was pretty interesting. We were suing, Spokio. They called themselves the People Search Engine. So I could search for you, and it would tell me all these interesting things like how old you were, your financial condition, your marital status, where you lived, all of that. The issue was, and I'm speaking back then. I don't know
Sure.
how Spokio is working these days. All the information was just bad. So, our client was someone who was young and unemployed, and it said that he was actually rich and married. They sold this information to employers. They also sold it. I believe you could buy it like if you were trying to date people to get, insight into.
Oh, God.
So remember, this is a while ago.
Sure.
And
it's basically just a data scrub of the internet. It's everything they can find.
yes.
Okay.
So it was just a total mess.
Uh-huh.
And so we sued under the Fair Credit Protection Act and Fair Credit Reporting Act, sorry, FCRA. And that was kind of the issue was, they'd given this bad information. It violated the act, but then the question was, okay, well, what's the harm there? And especially for this guy, this is why I kind of made it really interesting. Their argument was the facts that we got wrong were kind of better for him. He was richer. He was married instead of single. He was older. I don't know. And, our view is it's all contextual. If you're someone who's trying to get an entry-level job, it's probably not great for an employer to think that you're super rich because they think you don't need that job. And if you're dating, probably not the best thing for people to think you're married when you're not, or that you're 60 when you're 25. But, there were statutory damages. And, the question ultimately for the Supreme Court was, can you just automatically get statutory damages, or does there have to be some harm first in order for there to be Article 3 standing?
And had you won in the Court of Appeals? So you were bottom side?
Yes.
Yeah, okay. That's a Supreme Court nerd way of talking about it, but
Sure.
your bottom side, it means you won below. So you win in what circuit was it? Was it the third? Ninth. And then the other side files a cert petition.
Yes.
Do you remember who their counsel was? Was it someone?
Oh my goodness. It was Mayor Brown.
Mayor Brown. Okay.
Yeah.
And so did you do the what we would call a bio, the brief in opposition yourself, or what did you do when you saw the cert petition? I assume you have not been in the Supreme Court before this case. We
had not. So, we have an appellate team, and we had one back then.
Okay.
It was an interesting time in the Supreme Court because they were taking a number of class action cases.
So as I recall, this is like the height of what I would describe as the Kennedy Court, a very pro-business court. And I think I remember Spokio as being one of several cases where they tried to move the law, or at least some of the justices thought the law was best understood in a more pro-business direction. And I'm sure that was part of the impetus behind granting the case.
Yeah.
On your side.
It was clear that they were going to take a Article 3 case at some point.
So did you guys do the brief in opposition yourself?
So we brought in Will Consovoy.
At that stage. So before it was granted.
I mean, you're quizzing me about facts.
No problem.
I'm sure we brought him in at that stage. We didn't like pawn it off.
Yeah.
We were intimately involved.
No, of course.
But not necessarily.
Yeah.
We could have just.
Well, I know you well enough now from the last hour to suspect that you're not just going to hand this off. But.
Yeah. But that was a real learning experience for me too, because he, as you know, he clerked for Thomas. He understood the Supreme Court.
He's a conservative icon. I mean, absolutely. So how did you think of doing that? How did you find Will? Like, I'd love to know more about how a plaintiff's lawyer in Chicago, who's not a Federalist Society guy, ends up with one of the most iconic conservative appellate attorneys in this case about the internet and Article 3.
Yeah. Ashley Keller was the reason.
Okay.
I did not know Ashley.
Was he a funder at the time? What does it matter? But go ahead and tell the story.
I don't even know.
Yeah.
So at the time I was getting calls from everybody telling me what I should do on the case.
Because everyone thought it would get granted, I guess, right?
Yes.
Yeah, okay.
Or maybe it was after it got granted.
Yeah.
So maybe we did the cert petition. I don't know.
Yeah.
Luckily, this isn't being recorded, so I'm
Yeah.
not going to be embarrassed at my own firm. But I was getting calls from everybody, and mostly on the plaintiff side, telling me what I should be doing, which was to hire Deepak to do the case, or to dismiss it.
Oh,
Yes.
to avoid a loss.
Yes.
How did you feel about that advice?
So
This is a case you had won.
Yes. Well, so a couple of things. One is, and you would know this far better than I would, it's not easy once the Supreme Court takes a case to just say, we're going to dismiss. The Supreme Court can just make a decision regardless.
It does not project confidence in your arguments
Right.
to try to dismiss the case at the Supreme Court.
And we also knew that article, that they were going to take an Article 3 case. And then the question is, would I rather that I'm involved or give it to somebody else? And, my own arrogance, I thought if I was involved, that would be helpful. I also viewed the Article 3 analysis totally different than the rest of the plaintiffs' bar, as you know, but people did not understand this certainly at the time, and they're even confused now. Article 3 is about whether you get to sue in federal court, not whether you get to sue at all. So the kind of big irony as we're like briefing this, we didn't know if we wanted to win or lose. CAFA brought everything to federal courts. If we lost and there was no standing for these things, we could just file in state court for state courts where the jurisprudence was different, which is, there were at the time about 12 significant states.
Right.
And, again, just because it's not intuitive to people, but you can bring federal claims in state court. They're allowed to hear them, of course. Right. So what we viewed Spokio, the real danger of Spokio, wasn't winning or losing. It was getting it kind of muddled where it would make it hard for a class to be certified. We were really concerned the Supreme Court was going to say you need to do an individual analysis for each person.
I see.
And so that's what we were really focused on. I didn't think that other plaintiffs' firms were focused on that.
And why did you want Will to handle it as opposed to your own appellate team?
So,
excuse me.
Bless you.
Yes.
So Ashley called, and it was like the 20th call, but I will speak to anybody. Mm-hmm. And he said, look, you know him. He's not going to try to bully someone into a decision. He said, just, you should consider having someone who is fluent in conservative language, and who has a lot of experience in doing this stuff. So we met with Will, and I'm it's hard talking about it because of his passing.
It's horrible.
But he's just a brilliant guy.
No, he's everything. I mean, well, he was everything.
Yes, and someone who really loved the Constitution. Like, you start talking about Article 3, and it's like he was thinking about that since he was 2 years old. So it wasn't a hard sell. Once we met him, it was basically, what advocate do we want in the Supreme Court? And we want him Will. And it was one of the best arguments I've ever seen anyone give.
No, he was a phenomenal lawyer. Did you think about doing it yourself?
That was the plan before. Yeah.
And was that, I mean, I assume like most plaintiffs' lawyers, you have a relatively high opinion of your own abilities. Was that hard to sort of let go of this opportunity to argue at the court and pass it to somebody else? Or I'm just curious about the sort of, I don't know, emotional, personal aspect of this.
So I do have a high opinion of myself, but not in that way.
Okay.
I want to win first, and I want to be part of a team that wins. I really don't care if it's the next person up who can do a better job
Right.
than me. I don't care if it's a first year who can do a better job
Right.
than me. Like, we're gonna win. And the nice thing is, my name's on the door, so I'm gonna get whatever credit I get to the extent that what does it matter? Like in the universe, whether 8 people I don't know of think, oh, Jay's a little bit cooler because he argued in the Supreme Court.
Right.
That wasn't relevant to me.
Your kids would not be impressed. They would not care.
They've never been impressed by anything. But what was really interesting to me was, trying to figure out how to frame these really kind of important and complex issues. Like, just again, as a philosophy major, what does it mean to harm someone? What does the definition of harm mean? You can't even define harm without using a synonym in the definition. So my personal view is kind of harm is whatever society defines harm as. So, here in America, if I defame you, if per se libel, you've been harmed. That wouldn't have to be the case.
Right.
But we've just decided it is. And you can imagine, other societies say if you have some sort of voodoo curse on someone, they've been harmed. And we would say, well, that's just silly.
Right.
So to me, I just love playing with those issues. And then the strategy of it too, of obviously we're not going to say that before the Supreme Court because they would think we're loony. But what is a position that we think the Supreme Court might take? And I love the strategy aspect of that. So I didn't need to be the public face of that.
That's awesome. What a fun experience. Is that the only case you've had go to the court? That was your case?
Yes.
Yeah.
That's right.
Interesting. So I'd like to now sort of pivot a little. The first question I have is about the plaintiffs' bar generally. So I think a lot of people in the Federalist Society, much like we are taught law and economics as toddlers, believe the plaintiffs' bar is a bunch of sleazebags. It's really scummy. It's ambulance chasers. It's fraudulent. You know all the talking points.
Yeah.
Is that accurate?
Yeah.
Is it accurate as to some? Why don't you talk about that?
Yeah, it's accurate.
Okay. Just in general.
Yeah.
You too?
No.
Okay. Well, that's what.
So, no, I was.
Let's unpack that a little bit.
I was obviously kidding a little bit, but I think that there are different tiers in the plaintiff bar. I think that the top firms care a lot more about ethics. Still, a bunch should be caring more than they are. I think that we've been speaking out. As I'm sure you know, this isn't something we've been quiet about. One of kind of our key business strategies was to try to raise the bar on the plaintiff side because it helps us and it's the right thing to do.
How does it help you? I mean, do plaintiffs? I mean, these are not mostly just normal people. They're not super sophisticated consumers of legal services.
It's not that.
What is it?
It's the market setting of settlements. So what happens is that's what was killing us at the beginning before we had a name. We would bring suit and then the defense would say, okay, we've settled these 10 suits with other similar suits.
For
with
like
other
$1,000 or something. And you're like,
coupons, for,
garbage,
6 cents off a new truck.
Yeah.
And they'd say, so take that. And, my response of, well, we're not those kinds of lawyers wasn't terribly satisfying to them. So, one thing we really realized we had to do was take a very strong public stance that we're not going to do that. So the second you commit to things that are in writing, where you say, we won't do these types of settlements, that convinces defendants to stop saying you should do this crappy coupon settlement. We're saying that we're pot committed at this point. How can we do it? We've written articles about that how scummy that is. And then we started being put in a different...
So it almost gives you leverage in the negotiation.
100%.
Yeah, that's really interesting.
So yeah, I agree. There are a lot of... Marketing is a mess, what's going on right now with certain firms. It's not, the problem is, and it's true in business too, is a lot of times the people who have the most flexible ethical rules end up having just a widespread effect because they're willing to do things other firms aren't. So that ends up a lot of people see that, right? Like if you're engaged in illegal marketing, you're probably more likely to see the illegal marketing than the good marketing, because they don't really have any limits. So I think it is a good part of the plaintiffs bar, but I also have criticisms about the defense bar too. And I think,
sure. I mean, go ahead. But I mean, of course, neither side is angels all the time.
No, they aren't.
Yeah.
And I do think it's getting a lot better on the plaintiff side. I think, courts are caring more about settlements. I think that the marketing issues, I think will be cleaned up a little bit more in the next few years, and we'll see.
Well, let's unpack both of those just a tiny bit. So speaking of conservative icons, we have a mutual friend, Ted Frank, who I understand from Twitter is recovering now from a heart transplant, which I hope I never have to undergo. And I'm obviously very glad that he's appears to be on the mend. Was this settlement thing you were talking about how you got to know Ted? And I understand you guys are friends as well, right?
Yeah. I view him as a friend.
So is that how you got to know him, through sort of trying to improve settlement? Or how did you get to know him?
Yeah. So I've always had a view that I will speak to anybody.
Mm-hmm.
And at the time, Ted Frank was the boogeyman. He's still viewed like that in the plaintiffs bar. His goal, I was told, was just to destroy class actions. And so I spoke to him, and I actually read his briefs, and his briefs.
They're not. That is not his goal, as I understand it.
No,
his goal is to make them better.
Yes, and so,
or at least better for their intended purpose, which is not paying lawyers.
Yes, yeah, no, 100.
Right.
That is that is just objectively better. I think of serving our clients.
So you just called him up and said, "Hey."
I think that. I can't tell you, date and time.
Yeah, of course.
But, generally the way I remember it, first I started reading his briefs, and I was like, oh, I agree with this. Certain things I didn't.
Sure.
Though he's kind of convinced me I was wrong, like about Cypre, for example. That I
agree.
Yeah.
With him, and I guess now you.
Yeah. No, I'm happy to be wrong. And I was wrong about that for years. But yeah, we talked about kind of what he was trying to do. And I realized that first, he wasn't trying to destroy class actions. And then second, he ended up being a huge point of negotiation when I was settling cases. Because first I would say we're pot committed. And I'd say also, if you try to force a bad settlement, even if we're stupid enough to agree, Ted Frank's
this crazy guy's going to show up and object. And yeah.
And so this is where, people don't give him enough credit. They look at his specific cases and say, okay, and his track record's insane. And they say, this is, how much he's benefited consumers, but they don't understand, all of the other underlying effects.
Yeah, the systemic effects of his existence.
Yes.
On settlements where he never appears.
Yes. Where, my view is that he, indirectly, contributed billions of dollars to consumers, just from the threat of him getting involved.
That's really interesting. That is really interesting. Well, hopefully he'll be back on his feet soon and objecting to more bad settlements and doing other fun things.
He's doing better than he was a couple weeks ago, but
that's no small thing to have a heart transplant.
It's really scary.
Yeah. Well, I'm glad it appears to be going well and all of that. So let's talk a little about politics and how that kind of fits into your practice. So I guess first is just, have you always been a Democrat? Do you have any thoughts on the sort of generally Democrat lean of the plaintiffs bar and whether that creates, blind spots, distortions, or has some effect in how plaintiffs law is practiced, or like what issues people focus on?
There's
a lot packed into that.
Yeah. So in terms of have I always been a Democrat, I really don't understand the parties anymore. I definitely grew up in a Democrat household, voted for, was Dukakis the first time I could vote? If I didn't vote for
88.
Dukakis, so no, I was 16 then, but I was very into that campaign and, paying attention to every little thing.
So Bill Clinton would have been your first.
Yes. And, I liked him, for his ethics. And
He was very, very charming.
he was, and no, but I was totally bought in,
Yeah.
and I was totally convinced that all of these Republican smear jobs that he was, having affairs and mistreating women was just not true. And when he said I did not have sexual relations with that woman, I was like, yes,
It depends
Bill,
on what the meaning of is.
yeah, and no, but that that
Talk about a lawyer's lawyer.
but that was very disillusioning to me
Yeah.
in a good way.
Yeah.
So it's interesting, by the way, when Democrats now they're so opposed. They don't understand how people could vote for Trump based on policies because of their views about character issues. When Clinton, nobody had an issue with that at all. It was, yes, we don't think, at some point we realized he was not moral, but we like his policies, so that's good enough.
I mean, I tend to think most people know we are electing a president, not selecting a pope, and that it's a tool. Is this person going to do things that make my life better or worse? And character, it's important as sort of part of the thing, but it's, people are realistic.
Yeah, I mean, I think character does matter. I think character's hard to figure out, though.
I agree with that too.
So I mean, politicians, knowing really what's in their heart is a difficult thing.
It is not a purity business, politics.
Right. But I voted for Republicans, independents, mostly Democrats. And in terms of the plaintiffs bar.
And do you think people miss issues because they all think the same way, or it's a big enough bar that everything worth bringing gets brought eventually?
No, I think I don't think it's about politics. I think they miss issues because the plaintiffs bar all want to have safety in numbers.
I see.
So they all bring the same case, or wait for someone else to kind of prove that the case could be brought, and then they just rinse and repeat. So I think that's really the blind spot in the plaintiffs bar more than like ideology. But I haven't fully thought about that. I'm sure there's a ton of issues that they just wouldn't touch at all.
Yeah. So I understand that you've thought or spoken about diversifying your law firm in an ideological way rather than just other metrics by hiring some sort of Federalist Society kids. Do you have anyone like that now in the firm? And
yes. So
could you talk about that?
Yeah, it's funny. So I'm not really interested in ferreting out people's politics.
Mm-hmm.
I just don't want to run the firm like that. But, since I've started doing some of these Federalist Society events, we've found out that there are some secret FedSoc people at the firm.
Oh, no kidding.
Yes.
You're like, oh, I love that.
Yeah.
That's awesome.
And so that was interesting. And then we have, we're interviewing 2 laterals who are FedSoc people.
From big law firms?
Our chief of staff is out right
She's over there behind the camera. No one else can see her.
She would know the answer if they're from big law firms.
Okay,
I assume they're either from federal clerkships or big firms.
But these are youngish folks, not like older.
Yeah. Look, the firm, it's mine in name only.
Yeah.
So if you ask me like two questions deep about what our hiring
we'll
is.
ask Kelsey after.
If you really want to understand the firm, we should just turn this over.
I will do
Kelsey.
her podcast next week.
It'll be more interesting.
That's interesting though. So, I mean, and I guess Spokio would be an example. I mean, do you think there's a benefit, particularly in the appellate stage of a case, in having people who think on sort of all different ways about the law?
Yeah, but I don't view it just in terms of political leanings. I think that I don't mean to get kind of too philosophical here, but people's minds work differently.
Mm-hmm.
So I have something called aphantasia, which means that I cannot hold on to visual images in my mind. That to me has been a strength. It means that the way I think, I actually hear words a lot better. That's what I focus on. And my mind's not cluttered by visuals. It hurts me a lot too. I can't find, Starbucks, that's a total mess.
What do you mean? This is a digress, but what do you mean you can't find Starbucks? Like you can't picture the sign?
Yeah. So if you said there's a Starbucks over a block, you've got to go there and get back. That would be a challenge for me.
You have to read the signs.
I don't have like visual memories of it. So in order to, like, you would go to Starbucks and then would know how to get back.
Oh, I see. You
would
won't
have
be able to picture the block.
Correct. So I have to actually translate it into words, which is go out, take a right, look for this sign, then go in.
So can you, if I said, describe your wife
Right.
or your child, can you do that?
Not easily.
And the way you would do it is by what? Remembering the words that are in your head?
Yes.
So he is 6 feet tall and has brown hair.
I have to translate it.
But you could not summon that image. That's unbelievable.
Yes. Right. And
how old were you when you figured this out?
So I was an adult.
I mean, right, because you wouldn't know.
You never know how other people think.
Right.
So it's one of the reasons I was inconsistent in school, because when we would have like map tests in geography.
Yeah, you're like, dude, I don't know how to.
But
But you don't know that you're.
I didn't know. I was just like, I guess I'm not that smart.
Yeah.
Wow. So, and there are people at my firm. They have no inner monologue.
God, if only.
Right.
If only. I'd like to have that one.
That would be amazing. But so the way I approach things is having people who just think differently. It happens everywhere. People, the color green, people experience the color green differently.
Sure. I've always wondered that. What does it look like to other people?
Yes. And some people are colorblind. People interpret the world very differently. That to me is a huge strength. If you're firm about ideas and you've got people who just think they're just wired differently, that's a huge advantage. The political leanings, kind of, like the way that you speak so fluently about the stuff, huge advantage, right? If someone is at the firm and, can put that into words or can kind of educate us about how that part of the world works is a big advantage. Immutable characteristics have tended not to be as significant. There are some times when it can be relevant. The NFL concussion class action was an example of that, where there was race norming in terms of figuring out the damage amount. So black football players did a lot worse than white football players just because they were black.
In the settlement?
In the settlement, yes.
Really?
Yes, because
what do you think well, go ahead, explain.
This wasn't my settlement.
I assume you had the college analog, right?
Yes.
Yeah. Okay, but go ahead.
So my understanding of race norming is that they kind of would assume that black players were not as smart as white players, and so then if they were concussed, their damages were lower.
So this is just a wonky question, but how are these numbers being set? Like, who's setting these numbers? The plaintiffs and defense attorneys?
Yes.
On a person-by-person basis?
I mean, it's more complicated than that, but but in general, yes.
And so both sides are assuming the African-American player is...
They weren't doing that. They weren't doing that in a conscious way.
No, of course.
They weren't thinking about it. But then another firm, and I don't think it's a coincidence that the lawyer who kind of figured this out was or is an African-American lawyer.
Yeah.
He's like, this is totally messed up, and got the settlement changed.
Wow.
So there are times when kind of, having what everyone thinks of as diversity instead of kind of how your brain works can, of course, give you insight into things.
Yeah, I mean, it's just one metric in which people are differentiated and it may have different perspectives.
Yes, but I found that tends to be the exception rather than the rule. And if the more important thing is to get people just to have different approaches, and that ends up with better ideas overall.
I think that makes sense. So you've done a good amount of work with the Freedom of Thought Project and the Federalist Society. What has drawn you to participate in this? How did you first get linked up with the Federalist Society? Like why are you here and what do you get out of this?
Well, I figured first my brother would hate it. So that was the major reason.
Does he hate it?
I'm sure he does.
We'll send him the podcast.
He will not watch the podcast. it's kind of the same instinct I've always had. It's why I spoke to Ted Frank, which is this idea that you don't want to hear from people who approach things differently. It's just absurd. And what I've liked the most about FedSoc is that everything I've been involved in, it's just about ideas. Nobody has ever said to me, we need you to hit these points, or we need to check with you what you're gonna say. This podcast, I had no idea what you were gonna even ask.
We're not done. I got some real heaters.
I'm sure, but and that's what I like about it.
Yeah.
I've had really fun conversations with people who I wouldn't normally interact with, and I don't know, that's just been kind of fun for me, and I've learned a ton.
Yeah, so we did a panel, obviously, about the Supreme Court and the importance of judicial independence. And one of the things we talked about is sort of political polarization. As someone who is not, most Federalist Society people are pretty conservative or libertarian. You're sort of a different political ideology, as I understand it. What do you think are ways we can push back on polarization and try to sort of find more common ground as citizens of the same country? And the same planet, for that matter.
Yeah. So the first, I people sometimes misunderstand this about me. I like to actually criticize kind of my own group first. But so I'm going to focus more on what I think liberals are doing wrong rather than conservatives. That doesn't mean that I think there aren't extremists and conservatives, and there aren't a lot of messed up ideas. But I just think it's never that persuasive, to hear from a Democrat why Republicans.
No, of course, of course.
You go to MSNBC and you can hear all that stuff. So let me focus kind of on the left. We've gotten so far off track. I don't know what happened. The second that I started seeing conservative judges were going to Stanford Law School to talk about issues that they were deciding, and the response by Stanford Law students was to just yell them down.
Crazy.
I just as we're speaking, the idea that you don't want to engage with someone, these are people they're not fringe thinkers. They're writing opinions that are going to be the law.
He's a Fifth Circuit judge, yeah.
Yeah. So why would you not want to engage and understand their views and maybe even give some suggestions that could potentially influence them? And instead, the idea was we're just going to kind of yell them down. And you're seeing that more and more on the left. And I've been very outspoken about extreme DEI, which I think is just a disaster for the country. And part of it is setting up that to make sure that there are no debates, right? If I say you can't understand me because I have a different lived experience, I've got aphantasia and you don't, which means that whatever arguments I put forward, you cannot say are not valid.
Mm-hmm.
Great. Okay. Then there can be no discussion at all. Then we're 100% polarized. Mm-hmm. That's why, my view is we have to get away from that stuff. We have to get back to what I think, is the best of America, which is a real exchange of ideas. I would rather it's kind of a polite exchange of ideas, but after that, I would pick a non-polite exchange of ideas. The worst thing is when everyone's going in their corners and puts their hands over theirs and doesn't listen.
No, I certainly agree. Do you think people are starting to wake up to that the right way to win, if you think you're right, the way to win the debate is not to shut down the debate, but to actually, win the debate? I mean, do you think folks in your tribe, as it were, are starting to realize this?
Well, I think that anyone who has a view that you don't really want to defend your positions, I don't think they really believe in them. I think that it ends up being a lot more just virtue signaling. Yeah. And, you see it on different issues where when a couple questions are asked and the person can just repeat, whatever the new mantra is, and they don't really understand what they're saying. But yeah, of course, if you, and you're asking, are things changing?
Yeah.
And, the election, I thought potentially would be a wake up call. And, this seems to happen anytime there's, a loss like this, where,
Right.
Democrats lost Congress, as you know, and the presidency, you always see kind of a split of like half of the party is like, no, we actually didn't go far enough
Right.
to the extreme. Then the other half,
more cowbell.
yes, 100%. And then the other half is like, hold on.
What do you think? More cowbell or less cowbell?
I think that the idea that we just want to sum this up as this is a racist country, and that's why Trump won, and why Congress also went red, right? That's the hard part. Hard to do that, but
Trump got better margins with minorities than any Republican in many, many years too.
Yes, except that's against the talking point. So the response would be that can't be true, so it's not true.
It's fake.
Yes. So if you adopt those views, you're going to really ensure that your coalition is going to be small. You're going to push people out. I was called names simply for saying that it's important to understand why people voted for Trump, and maybe there are substantive reasons for it, and maybe we should look at policies. I mean, to me, I don't know if anyone cares about my politics, but
I do.
The worst part of Kamala's campaign was the question on The View of, what would you do differently than Biden?
The answer was just nothing, right?
The answer was I think he's doing great, which is fine if people think the country's on the right track, but they didn't.
No, of course.
And so to me, that was the big mistake of not having clear policies that were different than Biden's. And it's not like Biden had very clear policies either. So Kamala's policies were against price gouging. Okay, that's not really like a kitchen table issue. And then we're going to codify Roe v. Wade, which is not a possibility with this Congress. And then the third was we're going to tax unrealized income, which again is not a kitchen table issue. I think I'm a reasonably smart person. I have no idea how that would work.
It seems completely impossible, actually.
So,
I mean, if you think about it in terms of how a regular person's like, well, I bought my house for $100,000. It's now worth $500,000. Is she saying, in addition to my property taxes, I've got to pay a tax on the 400? What if it goes down? I mean, it's really odd to think how you would do this in reality.
So back when I was like really excited about politics, like in college, if you remember that, the candidates would have all of these like white papers on every single issue. And
this
now
was nothing.
It's just like a website which has a few words on it. And so I wish the Democratic Party was kind of more universally kind of focused on what we should be doing in terms of policy, rather than just view this as, everyone needed to vote against Trump because Trump's horrible.
Yeah, because he's Hitler or whatever.
Yeah.
So this is my last question, but it's a fairly broad question. There's a lot of young lawyers, well, at least 10, who will listen to this podcast. What advice would you have for people kind of at the beginning of their careers, or in the first few years, to have a meaningful, enriching, productive life, professional life that they'll be proud of?
So a few things. One is, I don't think that blindly following the path is the right way to go. I think that, people who go into law, you ought to do it because you've got your own views and you ought to be thinking for yourself. So if big law, for example, is the right thing for you, that's fine. But you should be thinking about it from first principles, not in terms of how will my friends react. If I've got Cravath on my resume, if that matters to you, fine.
Sure.
But you should understand that's why you're doing that. So I would always urge people to really think about what they want out of their careers. The second thing is I think that people really should be, early in their careers, be focused on jobs where they're learning as much as possible. I think that is really the gift you can give yourself. Whatever you're doing, if you're just kind of constantly learning at the beginning, you're going to be in a much better situation. Where a lot of these jobs, it's kind of stagnant. It's like, I'm going to do 3 years of like supervising doc reviewers, which I'm not going to do then the rest of my career. And to me, you've just lost out on 3 years. Those are the, 2 main ones. The third, which maybe is the most important, is I always think people should look, whatever path they're going down, look at the people who are 5 or 10 years ahead of them and think, do you want that job or not? And if you don't, then see if there's a different path. Maybe starting in Big Law is fine and there's a different path, but you got to find who those people are if you're following a path that you want to be like. That's what made it easy for me on the plaintiff side, that I could imagine myself being super happy on the plaintiff side, and I just could not see it in-house or on the defense side. And I'm sure people have exactly the opposite views too, which is good. And
are you happy with how it's gone?
I'm stunned at how it went. Remember, I was supposed to be, homeless or something. So this is all found money to me, literally and figuratively. So it's been super fun.
That's awesome. Well, thanks so much for coming. It was
Thank you.
Great to spend some time with you.